Thank you, everyone. Please be seated. Our next oral argument is Peterzalek and Weber versus Iowa District Court for Polk County. And it looks like the attorneys are all ready, and it's my understanding Ms. Den-Herder will argue. Thank you. And then it's my understanding for appellee it will be Ms. Beck. Okay, thank you. You may proceed, Ms. Den-Herder.
Good morning, Your Honors, and may it please the Court. Counsel, Alexa Den-Herder on behalf of Jeff Peterzalek and Molly Weber. Compelled depositions of opposing counsel have long been disfavored and are often a rare last resort. The question presented here is what burden a party must meet in order to depose an opposing counsel. This court hasn't answered this precise question, but the leading case across the nation is Shelton from the 8th Circuit. Shelton adopted a 3-part test which precludes the deposition of opposing counsel unless the party moving to depose has no other way to obtain the information is relevant and non-privileged, and the information is crucial to the preparation of the case. This court should adopt and apply Shelton to the facts of this case and conclude that the district court abused its discretion in failing to quash the deposition subpoenas served on the attorneys here.
The Shelton case, if I understand it right, specifically is relating to depositions of opposing counsel in the current or pending matter. Some circuits have applied that outside that context. But that is the fact pattern of Shelton, and I think that is the rule. Is that right?
The rule from Shelton is that the counsel in Shelton was not the opposing trial counsel. The counsel was an in-house counsel who had prepared some litigation matters for the case at hand. It certainly wasn't the opposing trial counsel. It was an in-house counsel who had prepared some litigation. While that was in the current instance, I don't think that it's necessary that it's a current counsel in order for Shelton to apply.
Circuit have the Pomida rule that deals with counsel for the same client in previous matters that have been concluded. So it seems to me that since they have two separate rules, that there's a difference between them, and that Shelton is about current counsel.
I think that Pomida was a very narrow holding, and a lot of courts have taken that to be a broader rule than what it was. In that case, they were deposing attorneys who had concluded a prior case, and that case was concluded, but the attorneys there had put their own work at issue. The privilege had been waived early on, and we just don't have that instance here. And the attorneys had put their work at issue in that case, and we don't have that same here. And
in this case, though, if I understand it right, Ms. Weber was the attorney for the department with respect to the Civil Rights Commission complaint, but Mr. Peterzalek had previously represented the department, but actually did not have any involvement in this particular case. Is that correct?
She actually prepared the prerequisite for this case, which is the ICRC complaint, the response to that complaint. You have to exhaust your remedies, and the ICRC complaint is the first step in doing that. So she was certainly a part of this case. While maybe not in the instant matter, it was definitely the beginning of the case. And I believe that counts here under Shelton. She's in that litigation capacity as the attorney, the in-house counsel in Shelton was. And for Mr. Weber, Mr. Peterzalek, he is currently counsel for IDPS. He has been for the last 20 years. Maybe he's not opposing counsel in this case, but he has a vast range of privileged information from his representation over the years. And while maybe and I want to be clear, he has not participated in this case in any capacity. He definitely has a broad range of information. He's been litigation counsel, and I think that his position is most analogous to the counsel in Smith-Bunge. In Smith-Bunge, which is a successor to Shelton in the 8th Circuit, the attorney there was an in-house counsel for a railroad. Her sole capacity, which was to advise directors about employment decisions. She was not involved in the case at hand. She was not involved in the litigation matters, and she certainly was not involved in the trial. And I think that Mr. Peterzalek is in a similar capacity here.
Help me distinguish, though, between Mr. Peterzalek and then you've got sort of the head of DPS is a lawyer. They have their own counsel who's a lawyer. They're getting deposed. The line between where we put them in the Shelton box and where they're not in the Shelton box, it's blurry.
serves in a purely litigation capacity for IDPS. He has represented IDPS in a variety of matters, including ones identical to this. The risk here is that you're going to reveal litigation strategy of IDPS in very identical matters at risk of deposing him. That's what that raises.
Still, I mean, Shelton says you can have depositions on non-privileged matters. It doesn't say that the fact that you have a deposition means you waive the privilege. He can go be deposed, and whenever a privilege comes up, somebody can say objection privilege. Why is that a problem? I was House counsel. It doesn't seem like a pretty significant obstacle to me.
Your Honor, first, it's the other party's burden to tell us what non-privileged information Mr. Peterzalek might have. Our trial counsel did an excellent job of trying to narrow that inquiry below, and that did not happen. We have brought...
I'm looking at their brief from the district court. It says he is, Mr. Peterzalek has directly observed Paulson's work ethic and interactions with others as an employee of the department. Paulson has also worked with him to increase training and awareness of harassment and discrimination within the department. Those strike me as outside the sort of legal realm.
Broad, and those are very broad categories. If they wanted to give us, dates, names, times, specific conversations, we could have put those guardrails up. And they also didn't limit their deposition testimony to that solely. That was just, some examples of maybe what the counsel may have asked Mr. Peterzalek about. And under the Shelton test, he's not the only person who has that information. Other people, they haven't proved that burden either, that he's the only person with that information.
Letter he wrote.
If they wanted to limit their deposition to just asking Mr. Peterzalek about the letter, he was the only person that could speak to that letter, and third, he was the only. It was critical to the outcome of the case. That might have been a possibility, but the district court did not put those guardrails up. It did not limit the inquiry of the deposition to that specific matter, and so.
City, do they have to have in outlining what discovery they're seeking? It seems like you're almost telling us they need to send you the questions, like the date, the time, the witnesses, what are you going to say about this letter? I mean, they've identified some broad subject matters. I believe he was identified in an interrogatory as somebody who has knowledge relevant to the case. He could still protect the privilege during the deposition. How much specificity do they need?
Attorneys are very are experts at narrowing trial or deposition inquiries. I think there's a rule that requires them to do so. And I'm sorry, Your Honor, I missed the second part of your question. My apologies.
I mean, I guess, why isn't this enough? I mean, there's a letter. You've identified him as somebody who has knowledge. You can protect the privilege by asserting it during the course of the deposition. He hasn't worked on this particular matter. He's only worked in prior capacities. I don't see what the issue is.
Narrow enough for us to know that privileged matters would not come up. Because of Mr. Peterzalek's vast range of knowledge, privileged knowledge from 20 years, there's not enough for us to know if we're going to get to a deposition and we're going to sit down and they're going to start talking about, privileged matters.
But you can interpose an objection at the time the question is asked.
Stops, and you can't continue the deposition on that matter until that objection was resolved. And so you have to go talk to a judge. It's a waste of resources, a waste of time to not narrow this inquiry before.
Let's talk about that. Let's assume that we were to adopt the Shelton rule, just hypothetically. Let's assume, well, first of all, what would we do next? Would we decide how it applies to Weber and Peterzalek, and would we be crafting these guide rules, or is this a better, adopt the rule if that's where we came out, and then say remand for further development?
The record is so scarce and there's so little to work with that here you could apply Shelton and quash the subpoenas, find that the district court abused its discretion and quash the subpoenas. However, if that, maybe you want to do that for one and not the other, however you come down, I think it would be appropriate to send it back down to the district court, say, please apply these factors, and then please impose it, if you find that there's non-privileged information that can be deposed on, please impose a better protective order, putting those guardrails.
Weber is in a different category, and I want to explore that with the other side. But with regard to Peterzalek, we had another one of these quash the subpoena cases a year or two ago, I think it was. And Justice Waterman, I think it was him, he wrote a concurrence about, why don't you try and talk these things through with opposing counsel and negotiate before you come all the way up the judicial chain? Was any effort made to negotiate the scope of his deposition?
Trial counsel, like I said previously, did an excellent job of trying to narrow down the inquiry. We asked multiple times through multiple emails, which I believe are in the record, what exactly are you asking for? Can we please narrow the scope of this so that we know when we sit down that we're not talking about privileged information? We filed a motion to quash in the district court. We tried to have that discussion there. It didn't work, it didn't work in our favor, unfortunately, but we had many of those conversations. We even offered the alternative of written interrogatories to try to narrow the scope, to try to help Ms. Paulson out, but no dice. They didn't agree to that.
Protective order, adequate protection?
Yeah, absolutely, Your Honor. The issue with the protective order is that it's just a seal of the deposition. The seal does not protect against the breach of attorney-client privilege. Once the breach happens, no going back. You can't patch that hole. So
I'm just really struggling with your privilege answer. I mean, this is really standard deposition stuff. People ask questions. Sometimes they veer into privilege. Sometimes they veer into work product. That's what the lawyer's there for. The lawyer interposes an objection. You continue with the deposition. And at some point, if the attorney thinks it's worth pursuing, you go to the district court and you get a ruling. I don't know why you think like the whole deposition ends as soon as somebody asks a question about privilege and then you have to reconvene. I'm struggling with this. I don't understand why you're saying that.
Such little idea of what Mr. Peterzalek is going to be asked about, it's very possible that wades into privileged territory more often than not. And for every question that DPS asserts privilege for, we have to have it resolved afterwards. Maybe we move on in the deposition to other topics, but at that time, we're not going to answer the question.
They have a good faith obligation not to ask questions that they know are just soliciting for privilege information if they know you're asserting it.
But because Jeff Peterzalek has such a vast range of privileged knowledge, it's very easy to wade into those waters. And like I said, even if inadvertently a breach happens, once the breach happens, it's you can't unbreach the attorney-client privilege once that happens. I want to go back to Ms. Weber. There's absolutely no, the dispositive factor here, like the district court said, is that she likely has no non-privileged information regarding this case. She served in a very limited capacity, which was to prepare the response to Ms. Paulson's ICRC complaint. She did so, and then that was the end of her representation of IDPS. All of the things identified by Ms. Paulson in her, subpoena is privileged information. Why a motion happened, why certain litigation strategies happen, are all privileged information. And there's been nothing that's been identified that is outside of that non-privileged category. At the same time, Ms. Weber, excuse me. At the same time, when you look to the third category of Shelton, which is critical to the outcome of the case, Ms. Paulson was more than happy to move along with trial without Ms. Weber's deposition. And I think that's another dispositive factor here outside of the fact that there's no non-privileged information. And I think once the district court said, hey, look, there is no non-privileged information for Ms. Weber, he should have tailored the protective order beyond just being sealed. He should have tailored it to, maybe just quash her subpoena altogether.
Isn't she entitled to some discovery into Me Too evidence or comparative at what happened to other people, harassment, discrimination at DPS?
Ms. Paulson needs to identify who has that information. Ms. Weber certainly didn't have that information because that's not the capacity she worked in within IDPS. I believe that they asked in interrogatories for that information, and Mr. Peterzalek had access to that information. It wasn't certainly information that only he had, and we asked to lift the screen to get that information from Mr. Peterzalek, and the opposing counsel didn't respond. So while maybe she's entitled to those types of comparators, she needs to identify who has them and why they might have them, and that did not happen here.
Drawing a distinction here, I think, between the idea of Mr. Peterzalek sitting down with counsel to come up with the list of prior complaints, right? And helping with an interrogatory answer on one hand versus sort of open questioning of him about all those actions that he might have been involved in one way or another.
Yes, Your Honor, those are two separate things, I guess evidence gathering and then and discovery, and then of course a deposition about those things are two separate matters. And we offered to get some of that information from Mr. Peterzalek, but of course there is a screen, which he has abided by this entire litigation, and we weren't able to get that from him. But he's not the only bearer of that information. He was just the easiest way to get that information. And certainly, a plaintiff's not entitled to the easiest way to get information, especially when it comes to the Shelton test, and the attorney-client privilege is at risk. And that's the same reason that Mr. Peterzalek's subpoena should also be quashed. Ms. Paulson was okay with moving along without obtaining a deposition from him. She said, nope, let's go to trial. So certainly these depositions were not critical to the outcome of her case. And if there are no further questions, I will sit down. Thank you.
May it please the court, counsel. The three fatal flaws of the state's argument are this: Mr. Peterzalek and Ms. Weber are not opposing counsel for purposes of Shelton. The purpose of writs of cert are to either sustain or annul certs, not adopt new law. And finally, there's been no request for privileged information in this case. Essentially, the state is putting the cart ahead of the horse. When we look at the Shelton test, it contemplates situations where a party wants to depose opposing counsel. The state's description of Shelton is slightly misleading in the sense that in Shelton, the in-house counsel that was sought for a deposition was also senior litigation counsel on that case. That attorney was also the individual who was responsible for gathering the documents in that case, and the reason the court adopted the Shelton test was because of concerns about Hickman versus Taylor in the work product doctrine, and how a questioning process about the production and assembly of documents could potentially invade that privilege. Instead, a few years later, the Eighth Circuit considered the Pomida case. And the Pomida case found this, that opposing counsel could be deposed in situations involving concluded litigation. Pomida essentially split it. There was ongoing litigation in Pomida where there's an indemnity action that had completed. The attorney's fees in that action, their involvement and work in that case, that was at issue in the case, so privilege had been waived. But the concern with Shelton was not at issue because the court elaborated more so on the reasoning behind Shelton, and that was because we wanted to protect litigation and strategy impressions of counsel.
Shelton and Pomida here. Mr. Peterzalek was counsel for the department, is counsel for the department, but on concluded matters, or at least not this matter. Is that correct?
Correct.
Ms. Weber actually did represent the department in this case.
Involvement, as admitted by the state, was extremely limited. Ms. Weber solely responded to the Iowa Civil Rights Commission on behalf of the Department of Public Safety. That was her only involvement. She didn't enter an appearance in this case, and she has since left employment with the state, so the concerns of Shelton about her knowing litigation strategy would not be present in this case.
Proceeding of this case, but the Civil Rights Commission, by statute, the plaintiff has to exhaust those remedies even before getting to court. So it's one piece of litigation, and she was part of it in this case. Is that right?
She could have possibly been considered opposing counsel, but because she has left employment with the state, she's not opposing counsel in this current litigation as it relates. But even if the court wanted to adopt the Shelton test for Ms. Weber, but not for Mr. Peterzalek, we can establish the elements of Shelton with regard to Ms. Weber. First, Ms. Weber is the sole individual with knowledge as to some of the actions that she partook in this case. And we're not asking, because I want to make this...
Right? But that seems really weird to be tapping a lawyer and say, we want you to talk about things about this in this case.
Weird, Your Honor, but it's actually not out of the norm of situations this court has considered.
You're a long time judge, a long time. That's just weird. You even said yourself, in this case. Help me get beyond that.
In 1986, the court actually considered a situation in Miller versus Continental Insurance Company. And in that situation, opposing counsel in that case was required to sit for a deposition when privilege had been waived, but also
Privilege had been waived. Let's assume no privilege waived in this case.
here is we're not asking for privileged information. With regard to Ms. Weber's involvement and the knowledge she has, there's a few parts to this. We can admit that her knowledge is very limited. Not every deposition has to be 3 hours. Her deposition would be limited to, first, she obtained a report. Our client, Ms. Paulson, submitted a complaint to DAS. Pursuant to the policies within DAS, that report should not have been released to the Department of Public Safety. But in Ms. Weber's representation of the Department of Public Safety, she somehow obtained that report and was able to produce it to the Civil Rights Commission. Then from there, when Ms. Weber submitted that report to the Civil Rights Commission, she filed an ex parte motion to seal that report with the commission, limiting plaintiff's ability to obtain it. So the only reason plaintiff even learned about this ex parte motion in the report was upon requesting the entire Civil Rights Commission file, seeing the email that was sent by Ms. Weber, and it included the ex parte motion as an attachment. This goes toward the sorry, Justice May.
A little bit, but I just want to get to the idea of the indispensable nature of Ms. Weber's testimony. I don't understand why we have to ask an attorney why a client took certain steps in litigation. Why can't you just ask the client? So why did you take these steps in this litigation? It feels very much like the concerns that the Shelton court had.
So Ms. Weber, we're not asking for why she filed the motion. What we more so want to know, how often does she file these types of ex parte motions to seal documents and limit an individual employee's access to information?
Witness. That's weird. You want her for a witness to help your client's case. You want the other side's lawyer to be a witness for you. I'll go back to when I was a lawyer. If I had a client and I'll make up an issue. Let's say the child at issue is handicapped. I have a handicapped child, but it has nothing to do with my representation of this client. All of a sudden they say, hey, Susie, you know a lot. We're going to put you on the stand. You had to deal with the school on handicapped issues. We just want to talk to you about handicapped issues. Nothing to do with this case. That's still completely wrong to try and make me a witness for my client, against my client. Isn't that what you're doing?
It is weird, but our rules of professional conduct actually contemplate situations where an attorney...
Unethical. To ask, what's the line that lawyer is risking at violating that attorney-client privilege by being a witness and that relationship, not just the privilege of communications, but the relationship. Okay, I'll represent you. By the way, I'm going to be called as a witness for the other side. Okay, unethical.
Ahead of the horse a little bit. There's not been an inquiry about a privileged communication at this point. In fact, the court's order denying the motion to quash actually highlighted that in situations involving depositions, you can still raise objections as to privilege. And I think this is especially relevant
to actually happen. Let's use my old scenario with myself. Okay, don't worry, client. I haven't said anything yet. Don't worry. I'm going to be deposed. Don't worry. Isn't that going to make her lose confidence in me? I mean, even putting me in that chair, cross your fingers that I'm going to do and say the right thing. Why does there have to be actual damage or maybe a request for confidential information?
And I'm not saying that we need a damage or request for confidential information, but let's look at it this way. In this case, the Department of Public Safety has already allowed us to depose their in-house counsel, Catherine Lucas, who is actually involved in the litigation. So your concerns that it's weird? Yes, it is weird. I will readily admit it's weird for an attorney to be...
I think it's really breaching that role of the important attorney-client, not only communications, but relationship.
Well, this court actually has allowed attorneys to testify in cases where they are opposing counsel. That was in Miller versus Continental Insurance. If we look at Fitzroy versus Jolita, the ethical implication isn't just automatically an attorney is a witness, then it's unethical. In fact, it's more so limited to situations where the attorney is a witness on an issue that is uncontested, it's not unethical. If their fees are at issue, it's unethical, are not unethical. And then in the third situation, when it would be a substantial burden to the client to have to find a new counsel once their attorney becomes a witness.
Going back to the Shelton factors, the third factor is that it has to be indispensable to your client's case. And I think here, if I understand correctly, your client said, we actually are ready to move forward with trial. We don't actually need this. Doesn't that resolve the Shelton factors?
I believe is an argument raised in the state's brief, but it misconstrues the record, actually. The state's prayer for relief in requesting the motion to quash was that the depositions, if they were to occur, initially involved a prayer that it occur within 7 days in our communications. Many folks who have done trials and been litigators know that trial perpetuation depositions take place on the eve of trial. At no point in plaintiff's resistance to the motion to continue did plaintiff concede that we were not going to want to take these depositions. In fact, the plan was still to take these depositions as we were proceeding toward trial. It's notable that the state also identified Mr. Peterzalek as the individual with knowledge of other acts of discrimination, as I believe Justice Waterman noted. They essentially did an implied waiver, as this court considered in Squealer versus Pickering Squealer Feeds versus Pickering. So by identifying him as an individual with knowledge, that waiver's essentially been there. But again, for Shelton to apply, they need to be imposing counsel for purposes of litigation.
Squealer, that case, the court signaled that you can retract the waiver and then restore the privilege that way. Isn't that kind of what they've done? They don't want to produce Mr. Peterzalek to respond by deposition. Is that a retraction of any earlier waiver?
They're essentially wanting to have their cake and eat it too. It was interesting to hear the state say that it's plaintiff's responsibility to identify those individuals that have knowledge within the state of other acts of discrimination. As the responding party to the discovery, it is the state that has the responsibility to find that information and produce it in the course of discovery. Also, importantly to know is the state is now saying that the protective order entered by the district court was not enough. But in the state's prayer for relief, they solely asked for a protective order in general under Rule of Civil Procedure 1.504, 1A in general. The district court did just that. If the state wanted to have the guardrails that they're requesting, they could have easily done a motion to reconsider, or a motion to enlarge and ask the court to provide more specific information and limit that request for protective order to section 1.504.
If I could jump back, I want to get back to Ms. Weber for a minute. As I'm hearing you, the only information that right now you don't have from Ms. Weber that you feel you need is the number of times she has filed similar motions to seal in responses to Civil Rights Commission complaints. Is that right?
Your Honor, and also how she obtained this confidential DAS report in the sense that, you know, if it's attorney-client privilege and her client had that privilege, then in the deposition, if they didn't waive it, fine, we can explore that further in a different way with fact depositions, but also
privilege, and she filed it with the Civil Rights Commission. That doesn't sound like it's attorney-client privileged.
that express waiver there.
So that seems to me an issue you don't need her deposition for. What's the relevance of how many times she's filed similar motions to seal? Why is that relevant?
Retaliation claim, it limits our client's ability to access the information. And in fact, we can recognize that Ms. Weber's information is much more limited than Mr. Peterzalek's. The record is replete with examples.
How does that go to the retaliation claim? It might limit the information you have, but you'll either ultimately get that report or not get that report. It doesn't go to the retaliation. The retaliation happened before, right?
We're viewing the motion to seal, the ex parte motion to seal, as a possible retaliatory act in her instances. But also, we only need to get to Shelton.
Seal the report in retaliation for your client's actions? Okay. All right.
Back up. So every time Ms. Weber would have filed a motion to seal or motion for whatever that you're looking for, she would have signed her name as the lawyer for that motion, right?
Yes, we're not asking for why she would have filed the motions. We just want.
So if that's a document, I mean, I'm no rocket scientist with technology, but it's a public record. And you have every right to go out and see how many times did Ms. Weber file a motion to such and such. You do the work. Why are you making her hand deliver? Because you just said when you answered a question from Mansfield, okay, fine. If they make an objection and say that's, then we'll go look somewhere else. Isn't that your duty to do that first?
However, the Civil Rights Commission proceedings are actually confidential, and we can't do FOIA requests to them. We submitted a request for a subpoena to the Civil Rights Commission asking for the ex parte information, and the commission doesn't, essentially either can't or doesn't have a way with its limited resources to provide this information. So there were other steps to try to find the information.
Provide the information.
The department, and that's exactly what we're asking with
Or to the department. How many times have you moved to seal responses to civil rights complaints or information provided with responses to civil rights complaints? Why do you need Ms. Weber's deposition?
Because Ms. Weber was the individual that filed it, but also under the rules of civil procedure.
Times the department did it. I mean, Ms. Weber is the attorney for the department. She may not have represented them in every single case, and her actions as the lawyer may not be relevant to the retaliation claim. So shouldn't the interrogatory go to the department to find out all the universe of cases, including those that Ms. Weber didn't represent them on?
Ms. Rand, I have an opportunity to answer. An interrogatory would be an option, but our rules of civil procedure give interrogatories as well as depositions as a basis to obtain information. As litigators, we all probably would have liked to respond to interrogatories instead of having our clients and our witnesses sit for depositions, because as lawyers, we can craft a response to an interrogatory. But at times, depositions are an appropriate and reasonable vehicle to gather information with the discovery process. And because Shelton doesn't apply, because neither Ms. Weber or Mr. Peterzalek are opposing counsel in this action, the court doesn't even need to get there. For these reasons, the district court's ruling should be affirmed. Thank you.
May I have one more? So let's assume we do adopt Shelton, and and whether or not we decide it applies to both attorneys or one or what. And let's assume, though, too, that we think that maybe Mr. Peterzalek could be subject to some degree of deposition, maybe Ms. Weber as well. Should we parse that all out for ourselves here, or should we remand that?
The court should remand it, but also the court could decide that Shelton does apply, but for purposes of Mr. Peterzalek, it wouldn't apply to him because he's not opposing counsel.
Thank you. I want to touch on a few points, especially Mr. Peterzalek not being opposing counsel. I think I touched on this briefly before. He is still opposing counsel. He represents DPS, which is the opposing party, or my client in this case. PMIDA doesn't apply to Mr. Peterzalek. They're asking questions about ongoing litigation, not about litigation that has concluded. I think I misspoke before. It is the plaintiff's burden to identify non-privileged information that they are seeking, not necessarily in the discovery context, but to identify non-privileged information that they want to ask Mr. Peterzalek about. As to Ms. Weber, her decision to file an ex parte motion does not go to Ms. Paulson's gender discrimination claim. I don't understand how it is crucial to the outcome or the preparation of her case as to whether an ex parte motion was filed or not. As to her gender discrimination case, and that would be the third prong of Shelton, a very important part of the third prong of Shelton.
On an earlier question, it reminded me of my special concurrence in the Detmers manufacturing case. Both sides have a duty to try to negotiate in good faith. Did you ever, or did the department ever say, Weber, Peterzalek, they're lawyers, but here's a different witness that can speak to these questions you have? Did you ever offer anyone up in their place?
He, deposed the director of DPS and Ms. Lucas, who is the in-house counsel for DPS, and I believe that they were deposed and probably answered the questions that Ms. Paulson had for them, if there were no objections in those depositions.
This up in federal court, it'd be a 30B6 deposition. In Iowa, I guess our current number is 1.707 5, where they asked the defendant to identify a corporate representative who then gets up to speed and is prepared to answer those those inquiries. Did that ever happen in this case?
I don't know the answer to that question. I apologize. I'm not sure if that was filed or not, but I do know that both of those individuals were deposed, and I think that those depositions are in the record. I also want to touch on the scope of the protective order. In our motion to quash, we did ask for a protective order narrowing the scope. It wasn't just a blanket protective order. It was a protective order narrowing the scope. I believe that's on the final page of our motion to quash. And one more thing that I wanted to touch on from your previous question, Justice May, was Shelton can be a fact-specific inquiry. It doesn't have to be a blanket rule that, you know, these are the only attorneys that can be deposed, these are the attorneys that can't be deposed. It might be, it's going to be a case-by-case fact-intensive question as to what attorneys are privileged to Shelton and which ones are not. It doesn't have to be a blanket rule that this court comes up with, but I think in this case, both Ms. Weber and Mr. Peterzalek are subject to Shelton. They're both still opposing counsel, or sorry, Ms. Weber is no longer opposing counsel, but she was opposing counsel in this matter, and Mr. Peterzalek is still opposing counsel for IDPS, not in this matter, but still with a vast range of privileged information and still represents IDPS in similar matters. To depose him risks the sanctity of the profession, as well as risks revealing litigation strategy for IDPS as a whole. I think adopting the Shelton test will make consistency in the district courts as to when opposing counsel may be deposed, which, as this court has previously said, it should be in a rare last resort. Yes.
I just want to ask you about a motion we got in this case from plaintiff about expanding the appendix, and if you have any response on that.
Expanding the appendix, you mean the motion that was filed yesterday around 4 p.m. of adding that doesn't change the outcome of today's case. Today's case, the question is exceedingly narrow. It's whether subpoenas need to be quashed in this case, and whether the attorneys at hand meet the Shelton factors. Does not really have to do with any ethics complaints or anything of that matter.
So are you objecting to the motion or consenting to it or punning?
Do you mean to it being added to the record in this instance? I imagine the state objects to that, or Mr. Peterzalek and Ms. Weber would object to the admission of that. Such a late and non-critical submission last minute. It does seem to be a bit unprofessional. And if there's no other questions, I will sit down. Yeah.
Do the concerns that drove the Shelton rule about protecting attorney thought processes, work product, and the right to have private confidential communications with your client, do those go away when the lawyer moves on to a different job?
Client privilege survives the separation of the attorney and the client. It even survives death. It's a very important privilege dating back to English common law. So important that the Iowa legislature codified it. In fact, it's very important. It's up there with the doctor-patient confidentiality, and I would say that it does not separate. When Ms. Weber left IDPS, she did not lose her privilege with IDPS as a client. Thank you.
And Weber versus Iowa District Court for Polk County is hereby submitted, and the court is now adjourned until this afternoon.